Hey everybody, Jessica Levinson in for Harry. I am a professor at Loyola Law School and host of the podcast Passing Judgment. And today I want to talk to you about a big state court evidentiary hearing that involves whether or not former President Trump is eligible to be president again. And the question is whether or not he's constitutionally barred from serving as the president. The question really focuses on a little known part of the 14th Amendment, which is Section 3. Most people know about the 14th Amendment. They think about the Equal Protection Clause or the Due Process Clause. I'm going to talk to you today about a lesser known portion that I've now added to my classes. It's not something that I used to teach before the Trump era. So broadly, we know that the 14th Amendment was added to the Constitution after the Civil War. And Section 3 is there to make sure that members of the Confederacy, people who essentially tried to destroy our system of government, can't then serve in government. And it says that if you engaged in an insurrection or gave aid or comfort to those who did, then you should not again serve as a senator, a member of the House, an elector for the presidency or the vice presidency, or in other federal or state or local office. Now, there is a case that is brought in Colorado. There's actually a number of cases, but I want to focus on the Colorado case today. There's a case that was brought by a number of voters along with a liberal nonprofit advocacy group called CREW. And what they're arguing here is that based on the events of January 6, 2021, that Trump is constitutionally barred from being the president again, and that he should not be allowed to appear on the ballot. So I really view this as a constitutional question and a ballot access question. Now, what's happening this week is that there's essentially an evidentiary hearing. It's before a state court judge. It's expected to last about 5 days, basically the entire week, to determine whether or not Section 3 applies here. But I want to talk about some of the legal hurdles that are brought up by Section 3. I think there have been, as far as I can tell, 8 successful cases brought under Section 3, and 7 of them were brought right after the Civil War. So this is a section that is not often used. We've seen this before with respect to the Trump presidency and post-presidency, which is he really has stress tested the Constitution. And here's yet another example of this. So the first questions in the case were whether or not these plaintiffs, these voters, even had standing to sue. And it looks like they passed that based on a Colorado law that essentially gives them the right as voters to walk into court and say, we are injured enough to bring the suit. The second kind of procedural hurdle is whether or not the case was ripe, meaning, is there anything left that has to happen? And again, it looks like the judge has said, yes, you can move forward with the case. That's why we're here for the evidentiary hearing, that Trump has in fact declared that he's a candidate. He's giving speeches. He intends to try and appear on every state ballot. And so that's enough. Now, those are procedural hurdles. Let's get to the big kind of substantive hurdle. I think the first hurdle is, does this section even apply to the presidency? So as I said, the section talks about senators, members of the House. It talks about electors for the presidency and the vice presidency, and it talks about other offices, but it doesn't specifically mention the presidency. I would offer to you that, yes, this is something that will be addressed in this Colorado case and other cases. It is a question, but it wouldn't make much sense to me if we are going to use this section, for instance, to disqualify county commissioners, but not the person who's seeking to be president of the United States. If the whole idea is don't hold a position of power in our government because we're worried that we can't trust you, that you might try and attack our democracy from within, then it really wouldn't make sense to say the leader of the executive branch, you're exempt from this particular section. Now, speaking of county commissioners, the last time Section 3 was used, in recent history actually did involve January 6th. It involved a county commissioner in New Mexico. And Crew also brought that case. It was a successful case. A judge said that he was barred from serving in office again. And he was somebody who was on the steps of the Capitol that day, I believe, and he took a bus tour trying to essentially rally the troops for January 6th. Now, next big questions, and these are the questions that bring us to this week, are, well, what exactly do we mean by an insurrection? What qualifies as engaging in an insurrection? The main thing I want you to know is I think all of the law indicates that you don't, in fact, have to have a criminal conviction for an insurrection. That instead, what you can have is exactly what we're seeing in Colorado this week, which is an evidentiary hearing to determine whether or not there was an insurrection and whether or not Trump engaged in it or gave aid or comfort to those who did. And part of this will involve witness testimony, expert testimony, eyewitness testimony. And one of the first witnesses here was Representative Eric Swalwell from California. I'm talking to you from California. And he testified, it sounds like very powerfully, and you can actually stream this hearing. You don't have to take my word for it. He testified about putting on a gas mask. He testified about a fellow representative who told him to use a pen as a weapon. He testified, and I think this is key, about his view of the link between what Trump was saying on Twitter that day and what was happening in the Capitol, and his feeling that you could draw a direct connection between the words that Trump was using and the actions that were being taken on January 6th, again, in the Capitol. So we're going to see a few more days of this testimony, and then the judge will make a determination. Now, we know that ballot access is state by state. So there are other suits that are pending. There's a suit pending in Michigan. There's a suit pending in Minnesota. And if in those cases, judges determine that, in fact, the Section 3 of the 14th Amendment applies, I just want you to be aware that there are different mechanisms essentially for how Section 3 is enforced. And in some cases, it looks like voters have to go to court. In some cases, there are administrative procedures. In some cases, the Secretary of State is envisioned as getting explicitly involved. So what I just want to flag for you is whatever happens in Colorado, that's the decision in Colorado. And again, because ballot access is state by state, I think what happens in Colorado could have a persuasive effect on other states, but certainly not a binding effect. If there is a favorable ruling for the plaintiffs, for the voters in Colorado, that would obviously mean that in the next cases, those particular judges don't have to be the first in the nation. And let's remember, this is a really big deal. It would be unprecedented. I know we use that word a lot, but it would be unprecedented to have decisions that say the former president of the United States, who's running again for the presidency, is constitutionally barred from doing so. There is some kind of political policy criticism that this takes the decision away from the voters. What I would say in response is the Constitution lays out the qualifications for being the president. You have to be a certain age. You have to be born in this country. There are certain residency requirements. And this is just another one of those requirements. So the Constitution takes away the ability of voters to vote for somebody who wasn't born here, who has not yet achieved the age of the requirement for the presidency. So yeah, the Constitution does take those decisions away. And I think based on why this became part of the Constitution, again, it's a post-Reconstruction era amendment. It's meant to protect us from members of the Confederacy who might want to serve in the government again. I think we can understand why we didn't want to put that question to the voters, why there are certain people who we did not want to put in a position of power. So I hope that's a helpful overview of what's happening in Colorado and what we can expect to happen in the other cases. Again, you can find my podcast, Passing Judgment, anywhere you find podcasts, and I hope to talk to you soon.
Hey everyone, Harry here. Hope you're enjoying the content from all the friends of our channel, great experts in their fields all. I want to thank them for stepping up to the plate while I'm away. I'll be back soon and I'm looking forward to resuming the daily videos. Talk to you later.